The October Visa Bulletin is here. This is exciting news because the October Visa Bulletin is always long awaited because the October Visa Bulletin brings the beginning of the new fiscal year. That means that generally in October, priority dates advance more than they do in other months. So here's what you need to know about the October 2025 Visa Bulletin. The dates have advanced in several categories. I'm not going to review that here because that's available lots of places, including the Visa Bulletin themselves, the Visa Bulletins, if you compare September and October. However, you do need to know that USCIS, the immigration agency here in the United States, has said that they are accepting I-485 filings. So that's the adjustment of status filings or the green card filings themselves for family-based and employment-based cases per the date for filing chart. So if you look at the October Visa Bulletin or any Visa Bulletin, you will see two tables, two sets of charts under family-based and two under employment-based. The first is final action dates. That means that those priority dates are actually current for that particular month. The dates for filing are dates the Department of State believes will be current in the foreseeable future. And every month, USCIS tells us whether they will accept I-485 filings based on Chart A or Chart B, the final action dates or dates for filing. In the month of October, USCIS is accepting filings per the dates for filing chart, again, for both employment-based and family-based cases. Keep in mind that if your priority date is not yet current per the final action date, your green card will not be approved until that priority date is current per final action date. However, for right now, for the month of October, not before October, don't file too early, but for the month of October, you can file, if your priority date is current, you can file using that dates for filing chart, which is amazing. There are lots of benefits to being able to file the I-485. A couple of things to keep in mind is, of course, your priority date has to be current. I'm not going to go into exactly what that means in this video. We have a separate video in our Sumner School Business Immigration Basics series on YouTube about what a priority date is. And we also talk about that in our Sumner School Family Immigration Basics series on YouTube as well. So check out those videos if you're interested in learning more about exactly what a priority date is. But basically, if you have already filed in the employment-based preference category, if you have already filed the I-130 petition, and if your priority date is current, and if you are in the United States in valid immigration status, you can file. Make sure you talk to an immigration attorney ahead of time to make sure you're eligible, which we'll talk about in a minute. But you can file the I-485. For employment-based classifications, for the most part, you have to have a certified perm labor certification approved. There are exceptions, of course, if you fall into the EB1 category and you're filing as for a national of extraordinary ability, outstanding researcher professor, or a multinational executive or manager, you may be able to file concurrently depending on your particular situation. Same thing for the national interest waiver, which falls into the EB2 category. Other types of employment-based filings, almost all, there's religious worker, but the rest require an approved labor certification. So that means that if you have not started the perm labor certification process, you're not going to be able to file the I-485. You don't have a priority date. Same thing is true if you have changed employers. I'm actually going to do a more detailed video on that next week during the live at lunch at 12 noon Eastern next Tuesday about the changing employers and the Visa Bulletin and perms and all of that, because I see that as a common problem a lot. But for now, if you have the perm certified, or if you're otherwise eligible to file the I-485 and your priority date is current per the dates for action date for October, get ready to file. So what do you need to do if you are eligible, if your employee is eligible, if you are an employer? Step number one, confirm that you are actually eligible to file. That means talk with an immigration attorney and make sure that you are eligible to file. There are various requirements to filing. It is not enough to just have a I-130 petition with a current priority date or an I-140 petition with the current priority date. Make sure that you're eligible to file. So you have to look at admissibility issues like, are you in the United States in valid immigration status? Are there status violations that could be a problem, or other immigration violations that could be a problem? Do you have criminal issues that could be a problem? All kinds of things that an immigration lawyer, qualified immigration lawyer, can screen for and should screen for before you file that I-485. You do not want to file it and then find out later that you have a major problem. My dogs want to come in to the office. So make sure that you confirm that you can file. Start preparing now. Today is September 15th of 2025. If you can file in October, don't file early. Unless you make sure that you're filing in the appropriate timeline. So if your date is current in October but not September, don't file in September because it'll be rejected. But you can start preparing now. So that means gathering the documentation that you need for the adjustment of status filing. That's none of this is legal advice, and I'm not going to sit here and tell you exactly what you need to file the I-485, but generally things like your birth certificate, your passport, your documentation of your immigration status. A couple of tips here. One is it is possible to go ahead and get your medical exam. Remember that those are required for filing the I-485 now. It used to be that you could file and then send it in later. That's no longer the case. So you can go ahead and get your medical exam done now. In addition, what we call civil documents, which is things like your birth certificate, marriage certificate, divorce decrees, death certificates for previous spouses, things like that, those have to match the reciprocity table, which is listed on the Department of State's website. So if you Google your country, whatever it is, so if you were born in Indonesia, just making that up as an example, then if you Google Indonesia reciprocity table, the Department of State website should come up and it will list exactly the type of documentation that you need for any given document, the marriage certificate, birth certificate, death certificate, things like that for previous spouses, obviously. So make sure that those documents match, because if they don't, you're probably going to get a request for evidence from USCIS. In addition, for the I-485 filings, you have to be physically present in the United States to file. So every time a priority date becomes current, so when there's a big movement like this with priority dates, it's inevitable that I have some clients that say, hey, my spouse is wherever overseas, so can we file for her? And the answer is no. They have to be physically, right now, they have to be physically present in the United States. So if you are planning on filing the I-485, if you're eligible to file in October, make sure your family members who are also eligible to file with you, such as spouses, minor children, are physically present in the United States as well. If they're not here, then they probably want to come back so they are able to file. Do not assume that the priority date will remain current and they'll be able to file later. They should be able to file at some later date, but the dates probably will retrogress at some point. And we'll talk about that in just a minute. Also keep in mind that this Visa Bulletin, the priority dates, it applies whether these priority dates apply, of course, whether you are applying for the green card here in the United States or applying for what's called an immigrant visa at a US consulate overseas. But those are two different processes. So if you are applying for an immigrant visa at the US consulate overseas, pay attention to communication from the National Visa Center and from the consulates about submitting documentation, scheduling an interview, things like that. But the priority date has to be current or close to current for that to be able to happen. So you're not going to be able to kind of get a lot of this documentation ready like I'm saying that you are if you're in the United States and you're able to file the I-485 in October. I spoke just a minute ago about priority dates retrogressing. So the priority dates for the October Visa Bulletin are what they are for the month of October. However, it's possible that in November, December, January, future months, we don't know exactly when, but it's possible, in fact, likely in some cases, that the priority date will retrogress in the future. That means that the priority date will move backwards, even though it's current right now for dates for filing maybe. It may retrogress in the future such that you won't be able to file. So don't assume, if your priority date is current right now, don't think, oh, I'll get to that. I'm really busy with work right now. I'll get to that in November, December, maybe turn of the year. No, you want to act on it now while you can. When the priority dates retrogress, if you have filed the I-485, they will keep, USCIS will keep your application in process. And somebody posted a question right here, and I forgot to say, if you are live with me right now, feel free to post your questions and I'm happy to address them if I can. I can't give legal advice, but this is a general question that I'm happy to answer. So post your questions, even if you're not live. If you're catching the replay, feel free to post your questions and I will certainly answer them if I can. So I was talking about, what was I talking about? get your family members here in the United States, you have to be, retrogress. If the dates retrogress, they will keep your I-485. They will hold it in abeyance. That's the term that they use, meaning they will keep your I-485 and you'll be eligible for these benefits, these interim benefits like the work permit and the travel document, which we'll talk about in just a minute. So file now, file when your prior, not now, but file when your prior to date is current. Don't assume that you'll be able to do it in the future because you may not be able to, at least for a while. So when you file the I-485, you are eligible to also, in general, you're also eligible to apply for the employment authorization document, which is often called the work permit. And you're able to file for the advanced parole document, the AP document or the travel document. When you file for these are called interim benefits. So these are benefits that you are eligible for, should be eligible for while the I-485 is in process. And that's true even if your prior to date retrogresses. You should still be eligible for those benefits and they will continue. Let's say your date retrogresses and you don't have the EAD yet, the employment authorization document yet, they should continue to process that and you should receive it in the future, even if your prior to date has retrogressed. The question is, how long does it take to get those documents? The answer is, it depends. In general, we are seeing that for the employment authorization document, it's taking around 6 months. Can be faster than that, definitely can take longer than that, but we're seeing in general, it's taking around 6 months to receive right now to receive the work permit. Those processing times and those estimates can change in the future, of course. The advanced parole document, we're seeing in general, it's taking longer. They used to process those together and people would get what's called a combo card, meaning one card that is valid for the work permit and the travel document. They're not doing that as much anymore. I've seen kind of a couple of rogue ones that have been approved, even though USCIS said they're not doing that anymore. So keep an eye out on your card once you get it. But in general, the advanced parole is taking longer. I would say closer to 9 months to a year. Again, it really varies. It can be shorter or longer than that. We have another question here that I'll answer in just a minute about portability, which is an excellent question. One other thing that I wanted to say about the advanced parole and the travel document, a couple things. One is people always ask, and it's an excellent question, do I have to maintain my status once I file the I-485? That's a complicated question. It's an easy question, complicated answer. The answer in general, and again, this is not legal advice. You should definitely talk to an immigration attorney about your specific situation. But in general, once you file the I-485, you are in what's called a period of stay authorized by the Attorney General. Again, that term is period of stay authorized by the Attorney General. That's a legal term, meaning you have permission to remain in the United States. It does not give you status, meaning you no longer hold, if you were here on F1 status, a foreign national student status, and you file the I-485 and then no longer maintain your student status, you no longer have status. You would not then be able to change to another status, but you would have permission to remain in the United States while you're here. However, being in that period of stay authorized by the Attorney General does not protect you from removal proceedings. So I'm not saying that they're going to come look for you necessarily, but if you commit a crime or otherwise come into contact with law enforcement, it is possible that you would be put into removal proceedings. So just know that that's not my recommendation. And again, this is not blanket legal advice, but my recommendation generally for clients is that you should maintain your underlying non-immigrant status for as long as you can until you receive the green card. I've also seen erroneous green card denials. We're dealing with one right now where they never sent, USCIS never sent the interview notices to our office or to our clients at all, even though we're getting other mail relating to that case. So there are erroneous denials. There are all kinds of reasons that it's a good idea generally to maintain status, but every case is different and there may be practical reasons that you choose not to do that. But again, make sure to get legal advice. The other thing that I wanted to say about applying for adjustment of status is be careful about intent. We have a video and I see this other question about portability that I'll get to. But be careful about intent. I have a video in Sumner School Business Immigration Basics on our YouTube channel, Sumner Immigration Law, that talks about intent. And this is true really for family-based or employment-based, but there are some visa classifications that are dual intent, namely, and specifically the H-1B and the L. Other visa classifications are kind of called quasi-dual intent. But my point is, if you enter the United States on a visa, you need to be careful and thoughtful and strategic about immediately or how soon you turn around and apply for a green card. So if you are outside of the United States right now on, let's say, a student visa, and you enter the United States, you probably don't want to turn around and immediately file an application for a green card. Again, it's case specific. If you're married to a US citizen, there's different guidance that is applicable or could be applicable there. So case by case, talk to a lawyer as always. But you do want to be careful about status. The flip side of that, of dual intent, is if you are in the United States already and you're eligible to file an I-485, great. But unless you are on H or L status, and even then talk to a lawyer, but unless you're on H-1B or L status, be careful about being able to travel. If you leave the United States and you don't have that advanced parole document yet, you could abandon the I-485 status. So, or the I-485 application rather, not the status, but the application. So be very intentional and strategic and careful about that. The question about can you file, and go ahead and put other questions if anybody has them. Can I file my I-485 and port to EB3, I-140 if I'm not employed by the employer who originally filed? So I don't have all the details for that, obviously, for that particular question. And of course, the lawyer answer is it depends. It depends on the specific details. What I will tell you, and my live next week is going to be about this in more detail because it's something I see a lot. People don't think about this until the priority date becomes current, or they don't prioritize it until the priority date becomes current, and then they're like, oh my gosh, what do I do? So this question is, can I file my I-485 and port to EB3 if they're not employed by the same employer? If you have not, portability in the green card process, employment-based green card process depends on, there are a number of requirements, a number of factors. One is that the I-485 must have been pending. You must have already filed an I-485 and it has to have been pending for at least 180 days before you port to the new employer. So the answer, generally speaking, is no. Again, that's not legal advice because I don't know the specifics of your particular case. But generally speaking, no, because the I-485 has to have been, you have to have filed the I-485 previously and it has to have been pending at least 180 days. There are other requirements as well. One of them is that the I-140 petition be approved or be approvable, and that you're moving to the same or similar employment. But like I said, I'm going to talk about that in a lot more detail next week, because every time dates move like this, I have clients come to me and say, hey, I have an approved I-140 petition. I have an approved perm, of course, because you have to have that for, if you're doing a perm-based process, you have to have that before you have the I-140. Anyway, they have the approved I-140, priority dates current, but they're not working for the same employer. They don't plan to go back to the same employer, and they have not started the perm process with the new employer. So we'll be talking about that. Make sure to tune in next Tuesday at noon Eastern, and we'll talk about that in a lot more detail. I also we have a couple more, one more question here, and I'm happy to answer any others. So keep putting them there if you have questions. I have a video, I might have mentioned this, but I have a video in Sumner School Business Immigration Basics about dual intent. So check that out if you're interested. Another question, what happens if you have to move a couple of months after you file the adjustment of status? What happens to the EAD and AP? And it also, is there a possible interview? So I'm not sure here if the person means move, meaning physically move, like to a new address, or move to a new employer, but we'll talk about both. If you move, once you file the I-485, just in general, if you are not a US citizen, you have to submit your change of address to USCIS. You can submit that change of address online through Form AR11, but you have to notify USCIS. That's required. Just, stop there. It's required if you're not a US citizen. However, it's critically important that you do that if you have some sort of immigration benefit pending, like the green card. So you definitely want to let USCIS know, because they will not forward mail that they receive, or they won't forward mail. So if they send it to if you have like more mail forwarding, if you move and have, say, oh, I'm going to forward all my mail. Okay, this person's asking the address. I'm going to have all my mail forwarded to my new address. So that'll cover that'll take care of it if I get the work permit, travel document, green card, whatever. No, the postal office will not forward immigration documents. So yes, you have to Make sure that you notify USCIS in a timely manner and try to make sure that that change of address goes through, because it doesn't always. If we're working with a client in that situation and they tell us, hey, I'm concerned about this, then we can mark a box on the G28, which is the form that says we are the attorney of record, to indicate that we want mail sent to our office instead of to the client. Mail meaning things like documents like that, the work permit and things to our office, and then we would FedEx it to the client or have them pick it up, whatever. So that is a possibility. What will happen to the EAD and AP if you move? Like I said, file the change of address or have it sent to your attorney of record. Yes, an interview is absolutely possible. It's always been possible, including for employment-based cases and family-based, of course. On and off over the years, we haven't had as many employment-based interviews, but we're seeing an uptick in those during the Trump administration. We saw them before, during the Biden administration and other administrations as well. So it's not just limited to that, but yes, it's absolutely possible that you would have an interview with USCIS. Another question, perm I-140 is approved, and if the employer is willing to support with the I-485, is it okay if not employed at the time of filing? So if I understand this question correctly, you have the perm approved, you have the I-140 petition approved with employer A, okay? Priority date is current, you're working for employer B, or maybe even down the line, employer C, D, E, whatever. You're not working for employer A anymore. So they're asking, can you move forward and file the I-485 if employer A is willing to support it? The answer is yes, if both you and the employer have the actual intent that you will rejoin the employer as of the time that you receive the green card. So the whole perm employment-based process is based on future employment. It's okay if you're working for them right now, or if you continue working until you receive the green card and thereafter, but it's not required. We have clients all the time who start the green card process for future employees. So they may be living overseas, they may have taken a different job in the meantime, whatever it is based on future employment. So both the employer and the employee have to have the intent that the foreign national will join that employer or rejoin that employer as of the time they receive the green card. So if that's true and you both have that intention, then that's great. Yes, you can proceed. The employer does have to sign the form I-485J. If you are submitting an I-140 and I-485 concurrently, it's not required. But if the I-140 petition is already approved, like you say in this particular situation, then yes, you have to your employer will have to, and you will have to submit the I-485J to confirm that that position is still open and available, or will be when you receive the green card. And like I said, intent is really important here. It has to be authentic intent to return there. You can't just say, oh yeah, I'll do that, and not mean it. That's misrepresentation and can cause major problems down the road, can be investigated, that type of thing. But absolutely, it's possible to do that. And I've had clients do that before successfully. Then the question is, how long do you have to stay there once you receive the green card? And that's a different question, right? For how long you have to stay there. I believe I have a video on that. I do, in my Sumner School Business Immigration Basics, about how long you have to stay there. So check that out if you're interested. So continue to post questions. I'll continue to check back and answer them as I can, as long as they're not, like I said, I can't give legal advice. If you do not have a lawyer, if you need a lawyer to help you file the I-485, we are here to help. Feel free to, we'll have an outro slide with our contact information. You can email us, set a time for a consultation, call. Setting a consultation or emailing is probably the best way to begin. And we are happy to assist. We help both employers and employees and individuals and families with this process all day, every day. And we would be happy for you to be our next client and walk you through this tremendously important process. We're very excited for everybody whose priority date is current. We wish you the best of luck. If you have found this information helpful, I hope that you will like it, comment, share this video with a family member or a friend, and subscribe to our channel so you don't miss our next video. My name is Emily Sumner, and I'm going to answer this next question just because it's here. Is a wet signature still an issue for the I-485? So USCIS accepts scanned signatures. So you have to, yes, you have to print the form, sign it with an actual pen, not an e-signature or anything. but then you can scan it and upload it. Like when we file, we have clients scan the signed forms that they have signed with a pen. We sign with a pen and submit it, a scanned signature of the copies. USCIS does require that you keep the scanned, or that you keep the original wet ink signatures. They can issue a request for evidence to ask for it. So you just have to keep it, but they will accept scanned signatures, which is amazing. So subscribe to this channel if you have not already. My name is Emily Sumner with Sumner Immigration Law. We assist clients around the world and around the United States with employment-based and family-based immigration matters. Until next time.